record. Summit would like to call their next witness.
Thank you, Your Honor. Summit calls Micah Rorie.
Feel free to move the microphone around whenever you need to. Make sure you speak into it. Go ahead and raise your right hand. Do you swear or affirm that the testimony you're about to provide is true and accurate?
I do.
Thank you. Go ahead.
Good morning, sir.
Morning.
Are you the same Micah Rorie who caused to be filed, pre-filed direct testimony with an exhibit as well as Exhibit H staff report testimony with an exhibit in this proceeding?
I am.
If I asked you those same questions here today, would your answers be substantially the same?
Yes.
Do you have any corrections or modifications to make to your testimony at this time?
Just the Exhibit H's are less than when we filed that testimony.
As of today's date, how many Exhibit H's remain?
We are at 892.
Thank you. Your Honor, I would move admission of Rorie direct testimony with Exhibit 1 and Rorie Exhibit H staff report testimony with Exhibit 2.
Thank you. Are there objections other than Mr. Jorde's standing objection? Okay, seeing none, will be admitted and given the weight due.
Thank you, Your Honor. We'll tender the witness for cross.
Thank you. Mr. Jorde.
All right. Good morning, sir. How are you? Good to see you again. Now, Mr. Rorie, your business address is in Iowa. Is it true you're a resident of Texas?
I am a resident of Texas.
All right. And you are an employee of Summit Carbon Solutions, LLC?
Yes.
Are you also, do you have an equity interest as well?
I do not have an equity interest, no.
Okay. Is your only financial interest that of an employee in the wages you make, or do you have any other financial interest in the overall Summit enterprises?
I think the arrangement with Summit has some sort of equity component there, but I haven't bought into the company.
At this time?
Correct.
Okay. But you would have the option if you wanted to exercise that option?
I'd have to look at the specifics how that all works. It's a component of the comp, but it's not. I'm not an owner of the company.
Got it. All right. Are you responsible for hiring the contractors who are out in the field, meeting with landowners, contacting landowners in Iowa?
I am.
All right. And since the commencement of this project, can you tell me the contractors, the companies that you've worked with?
Well, I wasn't here at the commencement of the project. I joined the project in late January, early February of 22. There's a number of vendors and right-of-way service companies that we utilize on the project. There's a range in Iowa. It could be contract land staff is the most prominent. You've heard folks talk about contract land staff. There's also TRC, which is another vendor there we use for right-of-way services, right-of-way agents, title research, etc. Then there's Upper Line Energy Partners and a couple other remote groups, depending on what type of due diligence we're doing.
And of the groups you just mentioned, do all of those have responsibility of landowner contact or outreach?
Most of them do, yes.
All right. And is it for the same purpose of obtaining easements?
Right.
All right. And so is there a methodology you use to deploy which specific group towards which specific county or landowners, or how do you go about those decisions?
It's a long answer.
Okay.
The methodology really is looking at experience levels, where they are found in our org, as far as the agents and supervisors, et cetera. So a supervisor would have a region and a number of agents that they manage. We had no real preference as to where those particular agents were placed. And you sort of go into this kind of blind, so you don't know exactly what type of folks you're going to be visiting with, so we don't really pair those up. We just try to spread it out methodically and start the conversations with landowners.
Is there any, I guess, plan or system in place, for instance, if landowner X, they have outreach by one of the firms you mentioned, doesn't go very well, not getting anywhere, and then here comes, contractor number 2, or, I'm assuming you have some type of a strategy where you have a landowner that maybe you're not breaking through to or having success with.
Not really. Sometimes it depends on the issues or concerns the landowner has. Sometimes those are elevated to supervisors or folks that coordinate meetings with construction managers or a variety of folks that go out there and talk with the landowner. There's no real plan in place to say, okay, well, if agent 1 is not successful, we're going to try to bring in agent 2. What does happen on these projects, which is very typical, certainly one of this length and scale, is that there's a number of folks that rotate out. So we do our best to take care of our folks, but they are contracted, and if they elect to leave or elect to go to a different region or something like that, then we need to replace them and pick up where we left off. So that's the most common scenario, especially on something that typically takes 6 months to a year, and we're 2 years into this. Some folks have chosen to head back to where other projects are and go different routes. So it is very common in a 2-year period to have 2 to 5 different right-of-way professionals visiting with the landowner.
Would you agree, even though that may be common, would you agree that that can lead to frustrations and some disconnect between the communications of what prior individual may have told or represented to a landowner and then what new person from new contractor is saying?
It's possible if the communication wasn't good. If the communication is correctly handled, then I imagine it can be a little bit confusing sometimes to deal with a new person, but as long as they pick up where they left off, they're typically not a bunch of frustration there.
And the firms that you mentioned, are all of those firms, I think you mentioned 4 or 5, are all of those still engaged and contracted by Summit within Iowa today?
Yes.
Okay. And have you experienced a fair amount of turnover or folks leaving to go to other projects over the last 2 years?
Not recently. We had quite a bit of it on the onset of the project for a number of reasons. Another long answer for you, but there's a number of reasons why that happened on the front end of the project. Starting this year, really tail end of last year, we really narrowed down a solidified team and have folks that have stayed very loyal to us and committed to executing the project. So we haven't had as much turnover this year compared to last.
If you can take me back to last year, and what do you attribute some of that turnover to that occurred last year?
There's a number of reasons why that was happening. There are right-of-way folks, especially on the contracted side. There's not an abundance of those folks in Iowa. There's not abundance of right-of-way work happening in Iowa. So several of these folks are not from here. There are other projects elsewhere that are closer to their homes, and there was a higher frequency of such projects early part of last year, middle of last year, than there are now. So that's part of it. The other part of it is it's a natural process where you figure out the folks that are completely committed to our culture and committed to this project, incentivizing those folks to stick with you is something that we did. But it's really just a natural process that happens on every project I've been a part of over the last 15 years. There's no difference in this one than any of the others when it comes to this topic. Early on, you sort of figure out what land agents are committed, and you only keep those that are, and those that are bought into your values and your systems, and you part ways with those that aren't. So there's been some releases too. It's not just land agents voluntarily leaving. I've made changes from management top down when it came to right-of-way services to make sure that we're delivering our message correctly and that we're aligning with the culture of Summit and doing this the correct way.
Has Summit let people go because they weren't being effective and weren't getting the job done, so to speak, weren't obtaining a certain quota of easements?
No.
And how are these companies compensated? Is it hourly, by the project? How do you compensate them?
They typically get paid by the day. So a land professional is typically paid a day rate. And then if they're away from home, there's per diem attached to that as well. And then they get paid for mileage if they drive somewhere.
So if Summit is paying them by the day, obviously the more they can get done and certainly the more easements they could obtain in a given day, the less you pay, right?
I'm not sure I understand. Help me there.
Well, if you're paying by the day, and it'd be better for this to take 1 year than 2 years. That's pretty simple math, right?
Right.
Okay. And so therefore, you would want to incentivize them to get as many easements obtained in a short amount of time, and that would reduce your cost, right?
There's other factors there, but yeah, we want efficient work, if that's the question, yes.
When you talk about the values, do you have a mission statement for Summit? Do you have an onboarding or an orientation process where you walk them through, say, a PowerPoint, or these are our values, or what do you mean when you say that?
Well, Summit values have been fairly public. You can find them on our website. You can talk about kind of the motive behind the project, our parent company, et cetera. You know, being from Iowa, being heavily invested in taking care of farmers and the ethanol industry, et cetera. So that's some basics there. As far as an SOP for the exact definition of our culture, no. It's really that's very atypical on the right-of-way side of things. You would address your agents, train them accordingly, make sure that they fit those values and align with you, and then you deploy them in the field.
When you mentioned the website, I'm just looking at it now. Do you know where that where the value statement or the mission statement might be located?
I don't know of a mission statement. I don't know where it would be on the website. I think if you look at, there's summitcarbonfacts.com. There's all sorts of points made there that tie into what Summit Carbon cares about, whether it be safety or ag or others. So a bullet point mission statement, I don't know if there is one or not, but I'm certainly aware of the values, and we make sure that our agents understand those.
Do the values of Summit include suing landowners and making them incur costs and expense just to later dismiss all the lawsuits?
I don't know if that's tied to a value. I think that's a function of project execution, but it's not a core value of Summit.
Has Summit or you, on behalf of Summit, fired or terminated individual people or contractors because of how they were dealing with landowners or unsatisfactory input from landowners of how they were treated?
No, I haven't fired anybody for that reason.
Has Summit received, either through your contractors or Summit directly, any input throughout the 2 years or concerns of how landowners believe they were being treated or approached by you or your contractors?
That was a long one. Could you ask me that again?
Yeah. What I'm getting at, the big question I'm trying to get at is what kind of informs, Mr. Rorie, how you go about deploying or overseeing these various companies and their interaction with landowners. And I'm curious if you have become aware of any complaints, concerns of Iowa landowners based on their interactions with you or your contractors.
Yes.
Okay. And how have you predominantly become aware of those kind of concerns?
Well, I stay in very close touch with all of my management team. I visit with agents frequently. Feel pretty aware of most conversations like that, we talk often. I read the reports. I look at contact notes. I look at records of what the agents are reporting on a weekly basis, typically. So I'm aware of those types of complaints, and we look into them anytime we hear about them.
And can you give, when you say like the management team, again, what is your role specifically? What's your title at Summit?
My title is Vice President of Land and Right-of-Way.
Okay, and so Vice President, Land and Right-of-Way, and then under you, are there additional Summit employees under you, or do we get right to the contractors?
There are additional people that are Summit employees.
Okay, can you just kind of give me like who reports into you from Summit?
So we have a title and due diligence manager that handles all of our courthouse research, general due diligence, everything that would be covered in the spectrum of title. And then I have two managers, one that covers South Dakota and Iowa, and one that covers North Dakota.
And can you give me the names of those two people?
Kyle Landry is the right-of-way manager for Iowa and South Dakota. Julie DeMeo is the right-of-way manager for North Dakota. Our title and due diligence manager's name is Ryan Callahan. He's out of North Dakota.
All right, and the people you just mentioned, those would be Summit employees that report up to you?
That's right.
All right, and then do those folks have the direct interaction with the contracting companies that we discussed earlier?
They also do, yes.
All right, and you have a centralized database where people can input their notes from communication with landowners, potential easement signers?
We have a couple of them, yeah.
Okay, could you just tell me briefly what are those, kind of what's the purpose of those?
Those meaning the databases?
Yes.
Well, it's important to be able to keep record of interactions with landowners, so it's not all on a verbal basis. So the purpose there is to track how those interactions have gone, what's taken place, what landowner concerns there may be, how we address them. There's also a lot of technical data in there tied to easement terms and distances and things like that. So it's just, you have to have a repository to capture all that information and house it. So that's the purpose of them.
And is it your expectation, or I should maybe say a directive or a contractual term between Summit and the contractors, that they need to input into that system their contacts, their daily contacts, or whenever they have outreach with the landowner?
Yeah, I think eventually they get into that system. I'm not going to say it's an immediate fluid process. Those contact notes have to be, generated, and then they get put in there.
All right, and so contact notes, is that a kind of a term of art? Is that a specific type of document that's generated, contact notes?
Contact notes is kind of over the normal course of a right-of-way project, that's a typical term. It just captures all the interaction with the landowner, whether it be via mail or phone or email or in person. It captures all of the types of interactions.
All right, and you mentioned reports. Is that a different type of set of data than the contact notes?
There's a number of reports I look at, but okay. I look at the agents, their rendering of what that interaction was, and that's how I'm informed about certain landowner concerns, unless I speak with the landowner directly myself, which I do often.
And that, so I just wanted to clarify, so the contact notes, is that kind of what it seems like it is, that this is evidence, I'm evidencing a contact, whether it's a call, a mailing, or an in-person, and it's kind of a running list of those actual contacts? Yeah,
typically. I mean, mailing sometimes is captured in more of a broad spreadsheet, right? But if an agent had a conversation with the landowner, it ought to be in those notes.
Okay, the fact that a conversation occurred, but not necessarily kind of the flavor or the substance of the conversation?
Sometimes they include that too. Okay. Sometimes if they left a voicemail, that's what they put. But they're to at least give us a summary of how that interaction went, if it occurred. If they mailed something or there was no response via phone or how that worked, then they're just going to document that. So they're responsible for documenting any attempted interaction with the landowner. It's not always perfect, but they do their best to capture that in the databases you mentioned.
And then, pardon me, and then the reports, if they want to express to you more of maybe a detailed interaction, is that known as a specific type of a report that would come to you, more of a narrative of the interactions?
I don't think so. I think that in general, they would type up their reports or their notes and put them in the database.
So if we wanted to find out, though, the best evidence and best records that Summit has documenting the interactions and conversations with a given landowner, we'd want to look at the contact notes, and what else would we want to look at?
Well, I mean, we would provide a summary of our interactions with the landowner, whether it's via contact notes or if I spoke with them or a member of my team spoke with them, they would give an account of how that went, their version of what was said, and the best recollection they have of how that interaction occurred. I don't know that it would be all in the contact notes. I don't know if there would be extra supplemental information there. It's kind of a mixed bag depending on what you're asking for. But we would do our best to give the most accurate account of our interactions with the landowner, whether that's via databases or affidavits or wherever that would come from. But it would be the best interaction we could give you on how things went between our agents or our management team and the landowner.
Okay. So when the contractors come on that have the land agents and are doing this work, as part of the contracting, do you attach to your contracts kind of, this is how we want you to do things, or do you assume that those companies are training their people in the appropriate ways to interact with landowners?
Do you mean by we want them to do things, you mean you want them to interact with landowners? Is that, or you're talking about databases? I'm just trying to keep up.
That's fair. So basically the interaction with landowners, the tactics, essentially, I mean, at the end of the day, I mean, you're basically making a sales pitch to, this is what we want, we'd like your signature. So is that spelled out somewhere of how Summit wants that to happen? Or you just say, you're an experienced contractor, this is what you do, just do what you do? How does that get communicated?
I think there was general training materials from the vendors themselves, right? Their own versions of giving the agent a general understanding of a carbon capture project, typical scenarios that we would run into visiting with an Iowa farmer versus a rancher versus a commercial property. There's no real SOP in terms of that training. A lot of it is verbal. A lot of it is through the vetting process. We make sure the folks that we hire are experienced and understand what they're doing. And if we're not comfortable with their grasp of what we're needing them to do, we don't deploy them. And so we spend quite a bit of time visiting with them, training them. There's a number of ways we do that. But no, there's no set manual I'm not aware of one that Summit would have handed to a land agent because it's not really a sales deal. There's no process flow for if X is said, then Y is your rebuttal. These are a wide variety of conversations to have with people about their individual grounds. So there's typically not an SOP there.
So, okay, do you send information or like best practices or protocols in a situation where a landowner is just simply digging in and not agreeing? I mean, how do you handle a situation like that across 4 different companies that are doing the same work for you across a given state?
Well, the right-of-way management, those folks that I mentioned to you, they also manage a number of directors and supervisors, et cetera, on the contract side. So there's management orgs in place right down to the agent in all of our states, but certainly in Iowa. So to answer your question, the process of if we have a landowner we feel is either opposed or not wanting to deal with us, or it warrants further discussion about individual concerns, then supervision and management is made aware of that. We always offer the opportunity to visit with the landowner from a management side of things, to see if we can temper those concerns, maybe provide more information that they're looking for that perhaps the agent couldn't provide.
Have you had reports either trickle up to you or reach your desk of various land agents being pretty aggressive and multiple contacts in a day, multiple phone calls, multiple knocks at the door, waiting on a porch for 4 hours, for instance? I mean, things like that. Have you heard of those type of things?
I wouldn't call it aggressive, but yes, a lot of those agents are doing what I'm asking them to do, which is to make every assertive effort they can to open a dialogue with the landowner and make every good faith attempt to have a discussion about an easement, and about the project or anything else the landowner may want to discuss. But in general, the instructions to the agent are make every attempt you can, within reason, to open a dialogue with somebody. Everybody's schedule is different. You may not know exactly when they're going to be available. You may catch them for 10 minutes, and it may lead to an ability to visit with the landowner a little bit longer later in the week. That's typically the way right-of-way is done.
Does Summit have a standard that it has shared with its contractors that, if landowner says, I am just not interested, please don't contact me? Is that, okay, now they get moved to the other list, everyone stand down? Or is it kind of, well, let's just kind of keep trying, try to crack the door open? I mean, how do you go about that?
There's no one set way there, but if someone is very much not interested, we try to find out why, to see what's driving that. If we can't get there, we can't figure out why, then we offer up to at least keep them updated on things. It's a long process. We try to keep folks updated on developments with the project, where we are in Iowa, how things are going, and that's been very successful. And in a number of ways, or a number of instances, I should say, that's led to a dialogue with the landowner. Because if we just simply go away when they say, leave me alone, I don't ever want to talk about an easement ever again, we simply go away, then in my opinion, we're not really making all the good faith efforts. I mean, it's a common thing for anyone to say on the front end of a pipeline project is, I'd rather not deal with this right now. So, okay, well, when's a good time to visit? Hundreds of landowners in Iowa have executed easements with us based on those types of continued dialogues. So I wouldn't call it aggressive. I just think we're being present, being assertive in some ways, but we're being professional in the sense that we're doing our jobs and trying to keep a dialogue open.
So when you utilize those strategies of continuing contacting, and eventually get an easement after many efforts over many months, do you attribute that to either A, you finally cracked through and they finally understood you, or B, they just got so worn out they gave up and signed?
Neither. Well, it's very hard to attribute it to one thing, but if I had to pick one, it would be that as this project has evolved, the public acceptance of what we're doing has grown. And so therefore it's become more acceptable for landowners to visit with us about the easement and reach an agreement with us. So I don't think it has anything to do with wearing anybody down, or obviously it has something to do with talking about easement terms and working things out. But as the project has evolved and as this process has gone on, I certainly have been made more and more aware of the public acceptance of the project, as evidenced by where we are in our acquisition numbers. And I think that's the main driver for why eventually folks say, okay, now I'm informed. I'm not simply hearing misinformation, or I'm not staying away from the facts. And I've done my own research and talked to folks that I trust about this, and I feel comfortable having a dialogue about an easement and reaching an agreement. So if I had to put my finger on one reason, that would be it. I'd like to credit my team for it, but really it has to do with just the overall acceptance of the project.
And for you to say, sir, public acceptance, do you have any way of measuring that? Or is your analysis, well, we were at 50%, now we're at 70, therefore we have 20% more acceptance? Is that how you get there?
What I mean by public acceptance is landowner acceptance.
Okay.
The folks that we're trying to visit with, I don't certainly gauge the public. That's not my wheelhouse. But yes, when I look at the fact that we have over 1,200 landowners that have executed an easement with us in the state of Iowa, yes, I do see that as acceptance.
All right. Okay, and that's fine. So your perspective is that's acceptance and not simply just giving up. I don't want to deal with these phone calls, emails, contacts anymore. I'm just ready to be done.
I see it as the former, not the latter.
Okay. You had said in your 2 answers ago of this kind of acceptance that they become more informed and understand the project. Do you believe that there has been misinformation about the project that has hindered your ability to obtain easements?
I do.
Okay. And do you believe it's important that a landowner, before they signed a perpetual forever easement, is informed and does have the ability to learn more about the project and its impacts?
Sure.
And so then why haven't you released until basically it had to be forced out of your council by this board, the dispersion and risk modeling and analysis so that people could actually make an informed decision of how many thousands of feet a deadly plume could travel when they're signing an easement?
Well, that's not mine to release, first off, so it wouldn't be my decision to withhold or release that. That's a company decision. Mr. Powell makes that decision, or somebody else at that level. What I'm talking about is information about carbon capture, its ties to the Iowa ag economy, the safety record of the 5,000 plus miles of CO2 pipelines in this country, the regulations that will be tied to this particular project that distinguish us from maybe a local project, a number of other sources of information there that eventually folks get a chance to take a look at. And they gain some comfortability with this being a pipeline project that's state of the art, regulated heavily not only by PHMSA but also by the various state boards. And so as folks gain that information and realize that there are a lot of other factors in play tied to safety, I don't often get asked about dispersion modeling, but I don't release that information either. I wouldn't know the first thing about it.
Well, I mean, certainly you wouldn't get asked about things that a typical farmer may not ever have even understood exists, right? I mean, you wouldn't expect on the first contact with someone in any county, Iowa, to say, well, what about that dispersion modeling? I mean, they have to be educated first to be able to ask questions. Wouldn't you agree?
I think every conversation is different when it comes to a landowner, so it's hard for me to give a general idea of what educated means, but we get a lot of safety questions from landowners, and we do our best to answer those questions or put them in front of the right people that have expertise to answer those. Very rarely do I get dispersion model questions. That doesn't translate into the landowner being uneducated or uninformed. I don't think that those are synonymous.
So when you say you have safety, you get safety questions, has Summit prepared like a bullet point or a fact sheet that they empower your contractors to say, hey, when you get these questions, hit them with this, 5,000 miles of pipeline and the kind of talking points? I mean, how did the agents know how to respond to safety questions?
Well, we give them a very short leash, so they don't make a promise or a commitment that's incorrect or give the wrong impression to a landowner. We take our integrity very seriously. They're not to lie about things, and they're certainly not to opine about things they don't know about. But to answer your question, there are FAQs or one-pagers that have been disseminated to a number of landowners about safety, the track record of CO2 pipelines. I don't have those memorized. I don't know when those would have been sent, but there's a number of safety-related materials that Summit's been pretty open about.
Well, do you have, though, a document or something that you hand out, like in the contact notes, Farmer Smith, really concerned about safety. Okay, let's get Farmer Smith our safety handout. I mean, how have you been educating them and responding to landowners that have shared those concerns? With what information?
Yeah, there's FAQs and one-pagers there that talk about a number of things. I'd have to look at the details of the safety related things that are in there. So I don't want to misspeak, but if a landowner is overly, the entire conversation is geared towards safety, or that's their primary concern. And the land agents are taught to cite the things I just cited, right? That this is not, an unregulated pipeline. There is history behind these. Here are the measures that we take in terms of valve spacing. A lot of landowners ask about that. Is there going to be a valve to shut this thing off? There's just a number of questions, Mr. Jorde. It'd be a long time me going through all of them, but there's a number of questions that come up. We provide information accordingly. If it gets very detailed, a landowner wants something granular, then my agents are instructed to never opine or shoot from the hip. We get them in front of our project manager or another member of our management team that has the expertise to try to address those concerns to the extent that they can.
Is it true, sir, that your one-pagers do not, and your FAQs do not go into any type of information relative to hazard risks, buffer setbacks, warning areas, dispersion analysis? Those FAQs that are out there don't touch that. Would you agree?
I don't know if they do or not. I don't have them memorized. It's been a long time since I've looked at our one-pagers, so I don't know if they do or not.
You say in your direct testimony that it's Summit's desire to obtain easements required for the project through voluntary agreement. My question to you is, you would certainly agree that with the, whether spoken or unspoken, ability to use eminent domain and to take legal interest in land from a landowner out there, that there never really can be a voluntary easement, right?
I don't agree with that.
Have you had anyone, after this project was announced, call you up and say, please locate this on my property? Like, please come to me?
We have.
Okay, how many people do you think would fit in that category?
Very small category.
Okay, all right, at least we can agree on that. And so this voluntary aspect, when you say and put forth to this board for their consideration, it's Summit's desire. Your desire isn't anything anyone can rely upon, because at the end of the day, we are here because you're asking for the legal right to take interest in land that hasn't been provided to you yet. Is that right?
That was a lot of questions. So I'll start with your first one. Desire or wishes or intent, however you want to phrase that, it's absolutely our intent to reach a volunteer agreement with every landowner on this project. We don't go into any of those arrangements or dialogues with the intent of only utilizing a last of last resort, unfortunate circumstance tied to eminent domain. That's not, our intent is always to find a way to inform the landowner, reach an agreement on an easement voluntarily, every time. So whether you call it desire, intent, or whatever, that's our goal. It's still our goal, regardless of these proceedings. It's our goal. Second question, we're asking for a lot more than just eminent domain authority or the rights to utilize that in the state of Iowa. We're here asking for a permit to build a pipeline. That is simply a function of what we're asking for. It's not so the way you phrased it, I feel the need to kind of clarify that we didn't show up here today with the intent of the only reason we're here is to talk about eminent domain. Now, eminent domain is an unfortunate circumstance. It is I believe, completely necessary function in the event that we're at a complete impasse with a minority of landowners, that in order for any infrastructure of this size and scale to be installed, it would typically need to be in play. But we as Summit, to go back to your question, intend to break our backs to try to make an agreement with the landowner outside of eminent domain.
If that's really your goal and intent, then you would agree that's premature that we're here, given all the landowners that haven't yet worked with you to meet your goal and desire, right?
No.
Okay. If it's truly your goal and desire to work with them to obtain voluntary, but yet in a month, 2, 3, this board could theoretically grant involuntary easements against all those people, then you wouldn't have met your goal, right?
Well, our goal is still the same, is to try to resolve and settle easements with folks. I certainly don't think it's premature that we're here. We're at an impasse with a number of folks. I think there's also a number of folks that are simply kind of seeing how the permit process plays out. So we have roughly 74%, 73.7% of the mileage acquired on this project. So the 26% I expect as these proceedings conclude and we're able to have a dialogue with some of these landowners, that those numbers will come down for that reason alone. So there are a number of situations where we feel we're completely at an impasse after exhausting all efforts, and that unfortunate circumstance would need to be in play.
Well, it doesn't really need to be in play. I mean, that's premised on, obviously, you're hired to do a job. I get that. But this question of need is premised on the fact that this project is even needed. And you understand there's a very differing degree of opinion on whether this project is A, needed for anything, and B, should it be allowed to utilize eminent domain. You're familiar with those arguments.
I'm familiar with the opinions, yes.
All right. Now, I don't expect you to share those opinions, but I mean, it's true. This project isn't transporting energy, right? I mean, the CO2 being captured isn't energy, correct?
I don't know if it's energy or not. I know it's a commodity, and I know that it's tied to a specific purpose that we feel is certainly necessary, and that's what we're asking for permission to do.
Well, it's obviously not a commodity because you're just putting it in the ground, and if we trust your application forever, and so we wouldn't, put valuable things in the ground never to be used, would we?
I think there's some opinions there about whether or not it's a commodity, but I'd refer you to council or maybe to look at the records on that.
And it's obviously a privately owned project. We know that. This isn't a public utility, right?
It's not a governing body as far as utility. I don't know the exact classification, whether it's common carrier or public utility. I think we classify as a common carrier.
But you would agree you're also not a common carrier because you're just transporting your own stuff on your own pipeline to your own holes.
Objection.
State your objection.
Calls for a legal conclusion.
Well, he's the one that said we're classified as a common carrier, so he must have some understanding to make that statement.
All right, Mr. Rorie, you can answer the question if you know the answer.
I want to make sure I clarify this. I'm not sure whether we're a utility or a common carrier. It's not really my call, and not something I discuss often. So I think we're a common carrier, but I'm not going to say that definitively. It's something I have to check with council or someone else at our company about.
Okay, or the courts and eventual litigation on that topic, most likely.
Your guess is as good as mine on that, or what the courts will do.
That's probably fair. Okay, so voluntary easement agreements. Now, you would agree that a pipeline route, which you rightly stated you're also asking for, is simply a series of connected easements. You can't have a route without the easement to locate. Is that right?
Can't have a route without the easements. That's correct.
All right. And the tracks that are still outstanding, I think you told Mr. Leonard, was it 800 and some, or what are the Exhibit H parcels as we sit here?
It's 892.
Would you agree that it's premature to be before this board when there's still 892 parcels and potential condemnation actions? Shouldn't you have waited and gotten more acceptance?
No.
Okay. You would agree that it would be reasonable for this board to deny your application and eminent domain requests based on the fact that you have no you have no approvals in North Dakota or in any other state, and you don't have the pore space needed in Oliver County, North Dakota, correct?
Would I agree with your statement that they ought to deny our permit as
Right,
tied to the reasons
Yeah.
you just stated?
Correct.
No.
okay. You think it's acceptable for Iowa to approve an application, approve eminent domain on 893 parcels, even though this project has nowhere to go with the carbon dioxide?
Well, I wouldn't agree that it's got nowhere to go. So that's your statement, not mine. I think given the way easements work in Iowa and the abandonment provisions tied to easements in Iowa, it's perfectly appropriate for continue to seek this permit.
Okay, even though this project and its viability in Iowa is 100% dependent on whether or not North Dakota allows you to locate your pipeline there and then sequester CO2 there, right?
That's your statement, not mine, but I don't see any reason to not seek a permit in Iowa as a result of how things are going in other states.
Were you aware that during our conversation here, North Dakota has denied Summit Carbon Pipeline's reapplication permit?
I'm not aware of that.
Okay. Would that change your answers at all?
No.
Okay. All right. Do you talk about steps Summit has taken to work with landowners to negotiate voluntary easements? I think we kind of went through that. And one of your exhibits, Exhibit 2, I guess the Exhibit H staff report, in that document, you've got various designations there, and one of them is LNI. What is that designation?
So that classification counts as landowner not interested. So it's a broad classification, but that's what that stands for.
Okay, landowner not interested. And to get in the landowner not interested category, is that a range? Is that, like the ones that scream at you and say don't come back, and the ones that are like, well, I don't think so? I mean, what do you have to do to get in the LNI category?
I don't know that there's one thing you have to do to be in that category, and I need to back up here. Those categories are pretty general in nature, and they're fluid in nature, so they change daily. But an LNI landowner is typically one that's just opposed to visiting about an easement, or they've been advised by their counsel to not talk to us. That's the two main categories there. That's subcategories of a landowner not interested. There's some others in there that, like you said, if someone's been violent or made threats, to where now we've got a safety issue and it's kind of hard to visit with those folks in person. We still try via phone, etc. But the vast majority of landowners not interested, or that category, is folks that we simply are at an impasse because there's very limited contact or no contact at all. And I would say most of those folks have been advised not to talk to us by counsel for a variety of motives I can only speculate about.
Are you referencing me there, or others, or should we get into that?
I don't think we should get into it.
Okay, all right. And well, it's certainly not uncommon when a client is represented by a lawyer that communications would go through a lawyer. You're certainly aware of that, those formalities, right?
I don't think that's uncommon. I agree with you there.
Okay. And then the in contact, starting on page 14 of your of this Rorie Exhibit H staff report Exhibit 2, page 14. Then it's in contact as a designation. What do you have to do to be in that designation?
I think those are folks that have shown a lot of desire to continue dialogue with us, albeit sometimes it's infrequent, but they want to keep a dialogue open, or they haven't really shown staunch opposition or some reason why they wouldn't want to be contacted anymore. But it's contingent on maybe their schedules. Talk to me after harvest. Talk to me after you get a permit. Talk to me when I get back in town. I haven't quite decided yet, but I'm open to visiting with you guys. I mean, you've heard a number of folks come up here and say that our folks are respectful. They're not terrible to visit with, by and large. I don't think so. And a lot of folks are continuing contact with us, but there's no real finality there. Not yet.
And so the folks in the talk to us after a permit category, I mean, that wouldn't be unreasonable in your view, right? Like, well, let's see if you can get where you need to go and then come back and talk to me.
I don't know that I would call it reasonable or unreasonable. It's just the objection that they have to executing an easement right now. So I don't agree with necessarily every one of those folks that says, well, I ought to just wait for a permit. So I don't know how to call that reasonable or unreasonable.
Is it true that Summit's internal strategy is if a permit is granted that you would go back to landowners and drop the offers?
No.
Is it true that currently Summit is decreasing its offers to landowners by 50% of what they were previously?
I'd have to look at the specific whatever scenario you're talking about, but we have lowered offers in some situations, but there's a lot more to the story than what you just presented.
Well, what would be the context? I mean, if you want to work with landowners, you want to do the right thing, you want to get to yes, and you want to have voluntary agreements, what possibly would be the motivation for going backwards on offers that you previously made?
There's a couple there. Normal course of negotiations with the landowner, there's often some finality as a factor involved. So when we look at if I were negotiating with you on an easement and I said, Mr. Jorde, I'm willing to pay you $1,000 for this easement and you're thrilled about that, do you think logistically we can get that done in the next 10, 15 days? And you say, you shake my hand and tell me, yes, I'll guarantee I'll get this done in the next 10, 15 days. And then you decide at day 16 or 17 that you've changed your mind. Well, those dollars were attached to the value of time tied to that. There's a number of other things they're attached to. If the parameters of that agreement are no longer in play and that fuse has burned out, then we're back to the drawing board. And that's very typical on a right-of-way conversation. I think the misperception is that right-of-way offers just constantly go up forever. And the longer you wait, the higher they'll be. And that is a misperception, especially at the premiums we're offering. I could understand if we were at bargain basement, tiny, levels. But if I have a limited amount of resources to spend working these out, right? One of those resources is time. So if we're willing to pay an excessive premium in the conditions of that arrangement with the landowner where that this would be done in 10 days, or let's call it a month, right? If 10 days feels unreasonable. And then we go 6 months and we don't hear from anybody. I feel it's unreasonable to expect the pricing to be at that same level when that wasn't the agreement in the first place. So that's one example of where all you would hear or someone would hear is that we've dropped offers, but really what has happened is a commitment was broken or wasn't upheld, and those dollars were contingent upon that commitment. They weren't perpetual dollars forever.
But given that example where you tied it in your example to say 15 days or there's like a time trigger, I mean, again, given the fact we're here, we're going to be here for a while. I don't know how long the board will take to make a decision. You need all these other states to make decisions. That putting landowners on a clock is really an artificial. It's a tactic, right, to squeeze them into signing an easement.
It's the furthest thing from a tactic to squeeze anybody. Whether I have folks working on a different time clock in Minnesota or North Dakota has nothing to do with what I'm working with in Iowa and the folks that we have working here. So it's the value of time. That's one of them. But again, very long answer for you because it's not just the value of time. There's also the framework of a relationship there. And you've heard folks say earlier that, it's the folks that worked with us earlier on, I think they took a little bit more of a risk, and dollars are tied to risk. So as this thing progresses and as the public acceptance I mentioned continues to evolve, as we go along these permitting processes and gain more traction or get to the final stages of this process, it's less of a risk. So there's a variety of reasons why an offer last fall may be different than an offer now. Sometimes they're higher too. It just depends. So there's not a general way of saying any of this, but I want to cite some of the situations in which the fiscal side of this could drop.
Are you taking this opportunity to send the message to those listening and interested in these proceedings that the offers are going to be going down, or do you have a commitment to hold them where they are, or what can you tell us about that?
Well, no, I'm not using this as an opportunity to send a message to anybody about this. I'm here to answer your questions. That's a common question. Are we going to keep things the same dollars wise? Really, and not in an effort to be Socratic here, but for what? We're missing quite a bit about what's being purchased here, which is the easement language. And there's a variety of back and forth in that easement language that has to do with value. So to say I'm going to keep an offer the same across the state is not realistic. Every one of those easements may have something different about it that either adds value for the landowner that reduces that payment, or adds value for us that increases the payment. So, and I tell landowners all this time, to the extent that they'll talk to me, is what we're purchasing at the end of the day is that language and a relationship, because that's what's binding, right? That's the relationship. And there's a variety of terms and conditions that could cause the dollar amount to change. So no, I can't commit to saying I'm going to pay everybody the same, or certainly the same amount. I can commit to paying them the last thing that we offered them. But every one of these are a case-by-case, individual negotiation, individual situation. And not all properties are equitable. Not all impacts are equitable. And I think it does a little disservice to the landowner to say that we would do something in general form across the remaining 470 folks we need to reach an agreement with.
You said that dollars are tied to risk. In that statement, is the risk meaning the risk of your project? So early on, when it's more speculative, maybe you pay less, and as it gets closer, you pay more? Or what was the risk analysis in that statement?
Well, what I mean by risk there is if early on, or I guess if you break it up into quarters, in the first quarter of this process, a landowner is being asked to have an encumbrance on their property, may not be built for a while, right? So he's got some scheduling and some things, or she does, that they've got to look at to say, okay, well, this is not happening for a while, or it may not happen at all, and I've got to have an encumbrance on my property that it may have to get released. And that's a little bit of a time risk for them, the way I see it. As we get further along the process, and 1,210 people have executed easements in Iowa, that's every one of those is an affirmation that the project is headed in the right direction. So the way I see it is, on the risk side, it's just the timing of everything as to when they need to farm things, or when they feel like they can kind of get both their crop damages and get their crops out of the field at the same time. It's a little bit different. So that's one, but again, you're citing one aspect of this, and there's many.
Okay, but I just wanted to clear it up. When you said dollars are tied to risk, that you were looking at as risk from the landowner's side, not risk from the company's side, or both?
I was looking at more on the landowner side. I'm asking the landowner to commit to something earlier than his neighbors.
Okay.
Right? I'm asking him to do something and be one of the first, or the first few. And that's not always the most comfortable thing to do.
So speaking of, when you're asking a landowner to do something that, to be first amongst neighbors, have you received any reports to your office of land agents telling people, well, all your neighbors have signed, so you should too, but in fact, that's not true? Have those complaints trickled up to you?
Well, if I was aware of land agents being deceitful about that, then they would be removed from our project. We would part ways with them. I'm not aware of any instances where a land agent went to a landowner and said, a number of people in your county have signed, or whatever, however they phrased it, and that they were being deceitful about that. What happens a lot of times is the landowner asks us, and we have to be very careful to protect kind of the arrangements with folks on the other side of their property line. But we get asked a lot of questions about, well, how are you doing in the county? Or how are you doing past the highway? Or how are you doing next door or down the road? If the neighbors are comfortable with us saying that, it's also sort of obvious, you know, in terms of if you look at Exhibit H's, we say, yeah, we're doing pretty good, or we're struggling, or we feel hopeful that things are going to improve, but there's a number of ways we answer that. If a land agent was to say your neighbor has signed and the neighbor has not signed, then that's deceitful and they'd be fired.
Are any of your company's loan covenants or financing arrangements tied to percentage of easement acquisition in any given state?
I have no idea. I don't deal with our loans.
Back to that Exhibit H staff report, the next designation is called legal assessment. What does that category cover?
There's a couple situations there. You know, as you well know, landowners, some hire counsel. If we're having interactions between our counsel and their counsel, going through a red line process, whatever it is, that may take some time for both sides. I mean, so that's one of those scenarios in legal assessment. Another legal assessment would be if the property had recently changed hands, if there was a foreclosure on it, something like that, to where we're sort of delayed in working that out. Then that's not necessarily the landowner. They could be very much interested in signing an easement with us. We may be holding it up if we want to make sure everything is copacetic and lined up. But majority of those are just red line reviews between our counsel or myself and landowner counsel.
And then it looks like the last category I have here is high counter. I take it that that's someone who has responded, but responded at an amount that you believe is unreasonably high?
Yes.
All right. And the high counter, do you go back to those people and try to get them into the legal assessment or in one of the other categories, or how do you work that?
I don't know that we would try to get them into another category. I mean, we do try to continue a dialogue with folks and try to reason with them in terms of if they're asking for, you know, excessive dollars or premiums that are, you know, unworkable. We try to reason with them and push back to the basis of our offer and what we're willing to compensate the landowner for. But I don't know that we would try to put them in another category.
So before I leave this topic, I'd like if we could have landowner 556 pulled up, please. And sir, while they're doing that, this is just an exemplar. I want to confirm this. What I'm going to show you is the Emmett County Survey Contact Report as filed by your company to the IUB. Once we can pull that up. Perfect, thank you. So again, kind of as an exemplar, got a little muddled at the top. I'll just report to you that this was filed by most likely your counsel on July 27th, 2023. I happened to pull this, but when you said contact report, is this generally the format of Summit's contact reports?
I think that's a summary for the testimony purposes. Formats are a little bit different when you get into the actual details of a conversation. It could be in paragraph form.
Okay, and that's what I was curious at, because you had said sometimes people can input, you know, the nature of the communication. So this might be a summary of your reports simply for reporting to the IUB purposes.
I think that's fair. I mean, there's ways to drop down the type of contact methods, and I think those are reflected accurately.
And then again, just so I understand, it seems obvious, but the contact method, that's how the contact was made, in person, voicemail, phone, email, letter. Okay, so that covers it. And then the date, agent, and then if we go back to the middle there, it says the landowner or the contactee, so that's the person who would have been contacted?
Yes.
All right, and then obviously they're tracked in Exhibit H. Okay, thank you. I just wanted to confirm. I'll offer Exhibit 556.
No objection.
With no objection, the exhibit will be admitted as Jorde landowner, hearing Exhibit 556.
Thank you. All right. Okay, you were asked to provide a general description of the content of the easement, and you attached what you describe as a template easement. I want to go through that with you. You talk a little bit about, I'm going to wait on that though. You talk a little bit about making fair easement offers, and you talk about CSR2 rating, the Corn Suitability Rating Index. And is that, sir, a piece of data that is fairly heavily weighted when you're making your initial offers on a given tract, or how do you use that?
How do we use the CSR2 scores?
In order to inform what an offer might be on a given piece of property.
We look at the CSR2 scores for an area. We look at it for specific properties based on the soil types. That kind of determines that score. And then we look at the county price point per CSR2 point to see what that per acre is going to be. If that was your question, I'm not sure.
Yeah,
if
well,
answered your
I just
question.
didn't, I'm sorry, I didn't know if you had a metric, like for instance, CRS2 score X, and then a way to get to value is that score times a multiplier.
It's that score times the county price point, right? So the county price points were kind of a hybrid determination based on Iowa land surveys to see, okay, here's what the price point is for the county. That's typical. It's typically an average. But if we look at specifics on a property, that may change a little bit. We always make it a little bit higher. So it's a multiple times the CSR2 score, and then look at, that's where you come up with your acreage value.
You also discuss crop damages and how you determine those, and your testimony states here on page 6 of 6 that, quote, the typical offer for crop damages totals 240% of the value of crops, comma, spanning a 3-year period with assumed rotation of crops, end quote. That's your testimony, right?
Yes.
But you're not paying 240% of the value. What you did there is you added up 100% in year 1, plus 80% in year 2, plus 60% in year 3, which totals an aggregate of 240%, right?
That's right.
Okay, I just want to be clear. If I have $1 in yield loss, you're not paying me 240% or $2.40, correct?
The way we structure this is the 180-60 tiers.
Right.
Right? So we're paying 240% covering a 3-year period for crop losses inside that easement, assuming a rotated crop model.
Okay, very good. I'm now, for everyone's purposes, going to switch gears to the Rorie Direct Exhibit 1, which is the supplemental easement. I'm going to be lengthy on this, and so I just say that I'm fine to keep going. I know we have a short day. I didn't know if there's a plan for lunch or what we're doing. I'm happy to keep rolling or stop. It's up to you.
Thank you, appreciate that. Let's roll till 12 and then we'll break for an hour, if that helps.
That is helpful. Okay, sir. And I might ask, please, if we could pull up, this is page 2 of Summit Rorie Direct Exhibit 1. It's the start of the easement agreement. Actually, I'll have you start on page 1 of that. Perfect. Yeah, if you could just stop there for a second. Okay, so here it says grantee is Summit Carbon Solutions LLC, and that means that's the entity that is the other contracting party along with the landowner who would be known as grantor, correct?
Right, the grantee is Summit Carbon.
All right, and that's also the name of the applicant in these proceedings, correct?
That's my understanding. I'd have to look at the exact entity name that was used, but that's my
And,
understanding.
I'm sorry, and then for the easements obtained, are those held within Summit Carbon Solutions LLC for now, or will those at some point be transferred out to a different Summit entity?
I have no idea.
All right, thank you. If we can scroll down to the next page, please. Yep, and we may even, if you would mind, just blowing up a little bit so we can follow along. Perfect. Yep, perfect. Thank you. All right, so I want to walk through this. Now, Summit Carbon Solutions LLC, we had some questions early on about, who's on the board, and I think I got a couple names, or at least Mr. Rastetter. Are you aware of any other folks who are on the board?
No.
Okay. Let me just read off some names and tell me if any of these ring a bell. Justin Kirchhoff.
Does Justin Kirchhoff ring a bell?
Do you know him? Okay. Are you aware that he's on the board of directors?
I have no idea.
Okay. And what about Jonathan Probst? You know Jonathan?
I know John. Yeah.
Okay. And are you aware if he's on the board?
No.
And Harold Ham, I believe we established. Do you know a William Berry with Continental?
I don't.
What about an Emil Henry with Tiger Infrastructure?
I don't.
Mike Stone with TPG Rise?
No. Never met with our board. I have no idea.
Okay. Well, you may have met him in a different capacity. Do you know a Jonathan Garfinkel with TPG Rise?
Sounds familiar, but I don't know.
And then apologize for this, but Jong Jun Yu with SKENS. Ever met that gentleman?
No.
Or woman? No? Okay. All right, so then back to the easement. It's with Summit Carbon Solutions LLC. Any idea why you're a Delaware limited liability company?
I can't speak to it. It's pretty common for LLCs to be Delaware limited liability companies. I mean, I don't know that I've seen very many in my career that aren't, but I have no idea. I can't speak to Summit's reasoning.
Certainly. Okay, and then if we can scroll down just a bit, we'll start at paragraph 1, grant. Thank you very much. So here, the first sentence, landowner owns the real property described on the attached Exhibit A, and then that's known as landowner's property. Is it true, sir, that landowner's property as capitalized term throughout the easement references the entire parcel?
No, that's not the intent of that, and that's not what that means. The landowner's property is just, instead of saying tract or parcel or ground or farm or row crop, we want to contain a consistent definition. I think I'm not sure how landowner's property is defined. I think it's the same way in the Exhibit H easement. You're looking at a voluntary easement. So I don't know if you're asking about both or if you just simply want to talk about this.
Well, I just want to go through what you attach to your testimony here, which is what we're looking at. And so, but landowner's property is intended to mean the overall property on which there will be or could be a 50-foot easement.
That's
somewhere.
right. That's correct. Yeah.
Okay. All right. And then it goes on, obviously, to talk about grant, sell, convey, and then for the use by company, and then a long list of people, agents, employees, successors, assigns, and then all those acting on behalf of it. So, I mean, is there anyone that's left out of that? It seems like you pretty much got it covered for anyone and everyone that can have access to or rights in the landowner property.
It's just a very typical way of defining a grantee.
Okay. Then in the fifth sentence there, it says starts landowner's property and then in the approximate locations. And you would agree that on the attachments, the attachment B that are attached typically to your offers, those are approximate locations that are depicted of the permanent and temporary easements.
They have the ability to be approximate, yes.
All right. And they're approximate because that gives you the ability to move the easement around and the pipe specifically if needed.
Right, gives us some flexibility if we need to adjust things.
And then subparagraph A, the pipeline easement, and is that what's also known as the permanent right-of-way?
Yes,
That would be the 50-foot width, correct?
that's right.
And within the 50-foot right-of-way, you reserve the right to move the pipe, whatever diameter, anywhere within the right-of-way.
As far as the permanent easement, yes, I think that's the case.
And then that goes on in line 2, and there's several lines there of purposes. The document is in evidence, so I don't need to go through every single one, but it goes on for several lines, and then we get down into kind of the middle there, and it talks about relocating and changing the route or routes. And so you or your successors and assigns reserve the right to relocate and change the route or routes, correct?
Yeah, it's very, very typical language for an easement to have the ability to realign or relocate or change the route or routes of the pipeline.
And then abandoning in place, so you, Summit, or your successors assigns, future owners have the exclusive right to leave the pipe in the ground or abandon it, correct?
No. So Iowa rules are different. So an Iowa landowner, if we abandon the pipeline or if it's determined to be not in use, and that there's a long road we could go down there, but if the pipeline is abandoned, then the landowner has discretion on their end. The default would be that we leave it in place, and that's per Iowa rules. But if the landowner elects for that pipeline to be removed and the pipe facilities to be removed, then we would need to comply with that. So we have the ability to abandon in place, and the default to abandon in place per Iowa law. The landowner can change that. We have the ability to abandon it at will, which is what that is stating there.
Okay, and I do appreciate the clarification, but what I'm trying to get at is if you and I'm landowner, you're Mr. Rorie, we agree on an easement, and it's certainly legal for it to be abandoned in place, and I sign this, I have contracted away my future right to say, oh, wait a minute, Iowa law says I have a choice, right? Because I've contracted it away here.
No. I mean,
That's not your understanding?
we can get deeper into the easement. It can talk about being subject to Iowa law, and that would control.
Okay, and we will. I'm just going to walk through it. So we'll have that I'll make a note. So you think the text later is going to control this paragraph here on the abandonment?
That's right. And, this gets very technical, Mr. Jorde, about abandonment. And what those verbs are doing is allowing us to operate and maintain the pipeline. If there's a section of pipe that we had to remove, replace, there are people out there that would say that it was abandoned. We just need the ability to do that. There's really nothing hidden there.
Well, I get it. I mean, I can read it. What I'm getting at is because, again, you're here asking for eminent domain powers and then the ability to have these terms unwillingly put on Iowa landowners. So I need...
Objection, Your Honor. I'm going to object to that characterization. This is a voluntary easement. The Exhibit H easement is much different than this. So I'll object to the characterization that anybody's trying to force this easement unwillingly upon a landowner.
Well, I'll remove the word if I said force unwillingly. So, but let me just rephrase. So what we're looking at here, though, if someone voluntarily agrees, obviously this is the language, but your point is later in the document, you say Iowa law controls, and you believe that would then automatically modify my agreement to allow you to abandon it in place.
Objection.
Is that what you're saying?
I'm going to object to the extent it calls the witness to give a legal conclusion.
Well, he's the one that started the Iowa law discussion and was educating me on Iowa law, so I think he's capable.
Mr. Rorie, you may answer the question.
Could you ask it again, please?
If you will.
Yeah, I'll try. All I'm trying to clarify, sir, is you understand that any two people can contract to anything as long as it's legal, correct? I mean, do you have that basic understanding?
Sure.
Okay. I mean, we can't contract to do illegal things. That would be a void contract. And what I'm getting at is, if I agree, yes, I will sign this, which I have given you, Summit, the right to abandon the pipeline in place. I'm just trying to confirm your point is, yes, but later in the agreement, it says Iowa law controls. And so even though I have signed this, I can later say, hey, Iowa law gives me an out.
Part of my answer is that if there would be a conflict there, that I would imagine Iowa law would control. But to our counsel's point, I'm certainly not a lawyer, and we'd have to look at that. But my point that I was making is that what you're reading, and yes, you can read it, it says abandonment, is not translated that way always in the field when it comes to maintenance. And so that's part of the reason, and I've seen this in my career several times, where you replace a piece of pipe and someone says, well, it's abandoned. Well, no, we had the ability to replace it at will. And that old pipe was abandoned, but we can replace it at will so long as it's the intention and the anticipation of use. There's a lot more to that verb than what you're citing there.
Well, I'm just reading it, and I agree it can be interpreted in many ways, which is kind of part of why I need your help to go through this. But let's move on, go down a couple lines. So those are all the lead in to all the things you can do, and then it's to place one pipeline not to exceed, and then depending what the inches are on the given property, in nominal diameter for the transportation of carbon dioxide and its naturally occurring constituents and associated substances and any pertinent facilities. Now, are you able to tell me what do you believe is covered under the phrases, quote, and its naturally occurring constituents and associated substances, end quote?
I am not the right person to go through the whole CO2 envelope. I couldn't list all of the constituents. Very generic, general form of describing a product that limits things to CO2 and CO2 related things. So that'd be the best answer I can give you. I'm not the chemist.
Oh, and that's fine. Are you aware that some landowners are concerned of what 10, 20, 15, 30, 50 years looks like, in that, hey, they say CO2 now, but this language, what could I be dealing with in generations? Are you familiar with those type of concerns?
We have had those questions periodically from folks, yeah.
Okay. And in terms of the individuals that are coming to testify, are you aware of someone that would be better to direct that question to, of how expansive that language is?
Perhaps Mr. Skubanek, perhaps Mr. Powell.
Okay.
I just don't deal with naturally occurring constituents of CO2 on a daily basis.
I don't either, and that's why I'm wondering what it even means.
I understand, but I would be shooting from the hip if I tried to list. I know that they're very small fractions, and that the vast majority of this is CO2 into the 98, 99% range, something there, but every either immeasurable or barely measurable constituent and what could occur there, I don't know.
Are you familiar with the Tallgrass pipeline project generally?
Barely.
Okay. Well, are you familiar that it was, when they got their easements decades ago, it was for natural gas, and now they're trying to do a conversion to run CO2 through it?
I've heard it's conversion. I don't know what from.
Okay. And that's all I'm getting at. You know, if your request here of the board is to allow you to have the right to potentially in the future transport whatever that covers, I'm just trying to understand what that is, but you're not the guy for that.
I can answer the question in the sense of what we tell the landowners.
That would be fine. Let's do that.
What we tell the landowners, this is a CO2 pipeline. And that if we wanted to change the product to oil or salt water or something that folks would be concerned about, a lot of the concern we hear is we don't want you to turn it into a natural gas line because that could explode and that's combustible. What we tell landowners is what we're seeking the permission from the board for, and all of our state permits, is for a CO2 pipeline only. That there is no way for us to change that without coming back and amending that easement or getting an entirely new easement from the owner of record at that time. So aside from all the permitting, retrofitting you'd have to do to change from a CO2 line to a crude line to a gas line or whatever product folks are worried about, that easement only allows us to do that. And that's the truth, and that's what we tell landowners.
But you would agree the language, anything that Summit or assignees, lawyers years from now could argue falls under associated substances, you would already have the easement to transport that.
I don't agree there. I mean, I don't know the rules in terms of whether PHMSA or some other regulatory body defines that envelope. I'm just simply not the guy to comment on that.
That's fine. Let's go to Part B, temporary easements. So we've got the permanent, the 50-foot right-of-way we discussed. Now we're on the temporary. And as we read through that first line into the second, it terminates on company, Summit, or whomever, delivery to landowners of written notice of termination. So it's not tied to the typical like 24-month limitation. The temporary is as long as and until you, Summit, delivers notice to the landowner.
No, we're required to do it within a reasonable time at the completion of construction, is what it says there.
Okay, and completion of construction, no idea, weather, labor, all sorts of things can affect that, right?
The completion of construction?
Correct.
Yes, there's a lot of things that can affect that. Yeah.
So again, the temporary easement, it's defined generally, but it's without limitations as to time because we don't know what the completion of construction looks like.
Other than that, time frame needs to be reasonable and close in proximity to the completion of construction.
All right, and the reasonability is something that's determined by Summit.
I would think that'd be determined by both parties. Again, I'm probably more of a legal conclusion on reasonable than.
Well, the landowner can't determine when it's reasonable to force you to send them a letter, right?
I think the landowner can say, "Are you done?"
Okay.
And we would have to provide reasons that were practical as to why we weren't. And if we were, then we need to provide something in writing that the temporary workspace is terminated.
All right. And then this too goes on, there are a couple lines, it's a free and unobstructed, and then it talks about for the purposes of, and essentially, I believe it utilizes the same, all of the same terms from the pipeline easement, the 50-foot easement, and then it talks about relocating and changing the route or routes of. So does that mean, sir, that within the temporary easement, you could go outside of the 50-foot into the temporary to change the route into the temporary, or what does that language mean?
On this form,
Yes, sir.
it just gives flexibility and it couples the temporary easement to be adjacent to the permanent easement. And so if the permanent easement had to fluctuate or we needed some flexibility there to move around a cultural feature or whatever the reason would be, that the temporary workspace would match the parallel fashion of that easement. So that's why you see the repetition of all those verbs.
And then let's go to C, the access easement. Now, we may have in another state talked about this before. Access easement, the way it's written here, I'll give my take, you tell me if you agree or disagree. The way that it's worded, I believe it appears to give unlimited and free and unobstructed access across the entire landowner property to get to the permanent easement. What are your thoughts?
Again, pretty generic comment in a lot of long-haul CapEx projects to have access to the right-of-way. Suppose I could talk about intent. There is just to be able to get to the pipeline, to operate and maintain it. We obviously have no interest in disturbing ground. We don't need to. It does talk about things being adjacent to the right-of-way and in between that and public and private roads. So that does not necessarily mean that it's the whole property. If you were to look at a property and public roads are on the south end and not on the north end, then that's just the ability to pull off the road and get to the right-of-way if we need to. I can tell you in general what this is for emergency situations. And if you look at the Exhibit H rights that we're seeking, that's exactly what it says. But It's very common for pipeline companies and certainly those that I've worked for to ask for an access easement. I don't see it as blanket access to the entirety of the property. I think it's contingent upon the location of public rights of way. So it's not the entire property, but also it's almost always tied to emergency situations.
Well, and I appreciate the intent and how typically things might happen, but there's no disclaimer or there's no requirement related to the public right-of-way. Those words aren't even in this paragraph, correct?
It says in the third line, adjacent to the easement lying between the public or private roads.
Okay, well, let me just read the sentence before that. A free and unobstructed, non-exclusive easement into, through, on, over, under, and across the landowner's property and over the property of landowner adjacent to the easement. So wouldn't you agree you can go anywhere and everywhere you want across the entire property to get to the easement?
I don't see it that way. We certainly wouldn't treat it that way, but I don't see it that way.
And then it goes on to say in the third line from the bottom on the right-hand side there, for all purposes necessary and at all times convenient to exercise the rights granted to it. And that's based on your or the future owner of this project's decision as to what's necessary and convenient for them, right?
Convenient for them to exercise the rights granted, not convenient for them just for sport. It would have to be tied to the rights granted, just to clarify there.
Sure, and the rights granted are access anywhere, everywhere, at any time convenient, right?
For the purposes, the rights granted to operate and maintain a pipeline, relocate, abandon, some of the things moving over.
Sure, no, I get that. I mean, eventually you're going to do something, but getting there, my point is, the way it's worded is you can travel anywhere on the property that you see fit.
I see it as in between public roads and the right-of-way, and also I see it as a voluntary easement template versus the rights being sought in Exhibit H.
So that brings up a good point. Did you give worse terms to the people that signed voluntarily? Because you keep talking about the differences between Exhibit H terms and the voluntary terms.
No, I wouldn't say that they're worse terms. It's just there's a different dynamic there in terms of what we worked out with landowners. Vast majority, I couldn't give you a percentage, but I'm under oath. Vast majority of folks were comfortable with that language, including your client that's executed an easement with this exact language.
Is that the one and only one?
It's the one easement that we've gotten with, through discussions with you, but that's the exact language that was there. So I have to assume that there was some comfortability there.
Well, would you agree that people's life situations are often different, and there's vastly different motivations of why and when and timing on when someone might sign an easement?
Well, there's a variety of those situations, but I don't think there's any variety in someone's reliance on their counsel to give them guidance on language.
Assuming that occurred, right?
Well, I have to assume if you were their attorney, it occurred, but I wasn't there. But they certainly executed that under your guidance, and so.
All right.
But that's just one example. The broader point is that so many landowners have agreed to this because it looks very similar to other types of easements that they've agreed to as they've held their ground. And obviously the company has no intention of running roughshod all over our property for sport. We have to pay for those damages. It damages the relationship I cited earlier to just be out there for no reason. We're not going to be out there. Plus, it's an absolute waste of money and time for us. So we like the ability to get to our right-of-way in case the property changes. We need to be able to get to the right-of-way. But beyond that, that's really the entire motive there. It's not to have blanket access to give to another company or however you phrased it.
And the client that you're referencing, I'm not going to say their name, of course, but that would be someone from South Dakota. Are you aware that their family was experiencing giant medical bills and felt pressure to accept this easement offer?
I'm aware that you shared that with me. I didn't visit with them.
All right. So let's go on to location number 2. Exhibit B again shows the approximate locations. And then the second sentence there, company shall have the right to select the exact location of the easements. And the easements refers back to all three, the pipeline permanent, the temporary, and the access. So again, you have that right to select the locations of all of those easements. You agree with that?
Yeah, we are showing an approximate location of the easement footprint. We are asking for flexibility via this document to alter that if we need to.
And then we'll drop down to number 3, the damages paragraph. You reference a damage calculation sheet. Now, you didn't attach an exemplar, but is it true, sir, if someone accepts the damages on the damages calculation sheet, which includes the 3-year payment for future crop loss, that then they are prohibited from coming back if the losses in those first 3 years are actually higher?
I don't really see it that way. I mean, that's the way it reads, is that we're trying to offer in excess of what anticipated damages would be, and very common to pay above and beyond on damages on the front end. It avoids those scenarios you just described. We feel 240% is ample, but if a landowner came back to us and said that they had a problem in year 3 to where they had yield lot, they couldn't get more than a 20% yield, which is, I've never experienced that, but in the event that that happened, we would work with them and take care of that. It's just the way that this is written is that there has to be a tie to what was paid. There has to be a tie to the paper and what was exchanged. And the damage calculation sheet shows a 3-year period. I'm comfortable in my experience in having been a part of installing pipelines in Iowa. I don't expect anybody's going to call me year 3 about 20%.
Okay, let's get through one more paragraph here before lunch. The restoration paragraph, now you've heard, I think it was Mr. Skuvanek, I believe, and others say, well, crop loss, compaction, we'll pay for that. We'll pay for that. You've heard that testimony, haven't you?
Yes.
All right. So let's look at paragraph number 4. And the main things in paragraph number 4, it talks about in the 4th line, restoring ground. And then we talk about restoring fences kind of towards the middle. And then further to the bottom, it's dealing with drain tile or irrigation systems. And would you agree, sir, that your commitment to compensate landowner in any of those for damage or problems in any of those situations is dependent upon the landowner proving to you that you or your contractors were the actual proximate cause of the damage?
Well, we certainly need to see the reason why it happened and what the claim is. It's just part of the natural process of that conversation. So yes, if the landowner said, I've got a deficiency, well, let's look at that. Where is the deficiency? Is it even on our right of way? What is this tied to? It's tied to a piece of tile, etc. So yes, I would need them to show me why this is tied to us.
Sure, but ultimately whoever owns this is the arbitrator, and you can just say, thank you, landowner, for all this evidence, we decline, and then their remedy is to hire a lawyer or sue or just give up.
I think there's other remedies there afforded via Iowa law. I think there's some compensation committee stuff that they can go through that's independent of eminent domain that they could go that way, but I've never seen it go that far. So typically, if it's very obvious if a pipeline had the unfortunate rare situation of having caused damage that wasn't anticipated. It's very obvious. It's not really an eye of the beholder thing. But we also can't be in a position via an easement, to your point, it's contract, right? Where someone can just call and extract money from us with no proof as to what that money was tied to and what we're paying for. So I think that's why it's written that way.
To your point that you've never seen something like that before, you would agree that it's intelligent when we're talking about a perpetual forever to the end of earth document that we think of not only what we've seen, but situations that may occur, right?
It's intelligent to think that way. Again, back to your question, this is a very common conversation where a landowner would say, look, I think you guys have messed something up here. We would go look at it. If we did, we would keep them whole.
Okay. Your Honor, this would be a good time to break.
Thank you for that. We will
Your Honor.
break. Sorry, go ahead.
If I
Mr.
may,
Dabrowski.
I think it's important to clarify the record. Mr. Jorde interjected early in his conversation with Mr. Rorie, his belief apparently, I'd like to hope it was his belief, that North Dakota denied the application for reconsideration this morning. My understanding is that is just simply not correct. They had a work session, no vote was taken. I think I won't characterize it farther than that, but I will say I think that Mr. Jorde's characterization was simply incorrect.
Yeah, I asked him a question. I didn't state it was fact. I can tell you my email's blowing up, but in any event, whether it did or didn't, he didn't know, so it's really a moot point.
Well, I think Mr. Jorde should certainly be required to not engage in things that are not factual in his questioning, but be that as it may, North Dakota didn't make any decisions. I think that's important to clarify for the board.
Thank you. Okay. We will be back at 1 p.m. on the record. Sorry, did you